speaker is Elyse Dorsey, attorney advisor for Commissioner Phillips at the FTC, and is going to be speaking to us about Antitrust's new inhospitality, I was like inhospitable, but inhospitality tradition. So,
all right, thank you.
All yours, Elyse.
And thank you. I'm very excited to be here today and have the opportunity to speak with everyone. This has been a super interesting conference so far. Before I get started, I want to make sure to say out loud that the opinions I'm expressing today are just my own. They are not necessarily those of the Federal Trade Commission nor of any individual commissioner. So I thought today, we heard a bit this morning about how antitrust has become increasingly popular and increasingly part of the popular conversation. And tech in particular, so antitrust has grown, as I think Roger was talking about. In the 90s, there were maybe 20, 25 jurisdictions that had antitrust laws, and today it's well over 100, closer to 130 jurisdictions that have it. And at the same time, the technology companies have been growing and expanding globally as well. So both antitrust and technology have become more of a global issue. There's a lot going on there, and a lot of the rhetoric that we're hearing today tends to be a bit hostile to the technology companies. There's a concern, lots of concerns that they have grown too big, they're doing things we don't understand, and so antitrust needs to take a more proactive, or the other term is precautionary approach, and sort of ex ante say, okay, we're going to be more skeptical, we're not going to let you just act and let the free market take care of things, we're going to intervene earlier, we're going to take broad categorical approaches. And this is actually very reminiscent of a bygone era of antitrust in the United States, where earlier on we saw a lot of this. The courts were very skeptical. They would say a lot of things were found to be per se unlawful and treated with a lot of hostility. Over time, the courts abandoned this as they kind of started to learn that the things they thought were bad in the first place were maybe not so bad. And so today take a more considered, more thoughtful approach and generally act under the rule of reason. But we're seeing a bit more of inhospitality maybe making a comeback. So we're going to talk a bit about that. And then wanted to talk a little bit about the implications of whether maybe a new inhospitality tradition for technology and antitrust is warranted today. So I thought it might be interesting to start just by laying some groundwork, because I think the topic for today's conference is very timely. So basically, in the 2016 election was the first time in about 30 years that a major party platform had included specifically antitrust prescriptions. And the Democrats continued this after the election. They offered a better deal, which includes more prescriptions on how we should treat monopolies and be more active in antitrust. And then in this year, the House Judiciary Committee launched a bipartisan investigation into competition in digital markets. The Federal Trade Commission established a new technology task force that has recently, for ministerial reasons, been renamed the Technology Enforcement Division. The Department of Justice announced they would be initiating an investigation into leading online market platforms, platform markets, and in the presidential campaign as well, we see a lot of current senators and current folks running for president offering up a lot of proposed solutions that, again, are prescriptive. We're going to intervene earlier, we're going to set out some broad rules. And so this has kind of led to a lot of reporting. Bloomberg saying antitrust has become such a big deal that it seems certain to be a dominant theme in the presidential election. The last time that happened was in 1912, making it 2020 the year of the great antitrust reawakening. And if you take a look at the headlines, just in newspapers and sources online, that seems to be not untrue necessarily. There's a lot. It feels like it's kind of every day. There's a new headline about antitrust in tech and what tech is doing wrong and the consumer harms and how enforcers haven't been doing their jobs. So one thing I thought would be interesting, because I live in DC and I work at an agency that is tasked with enforcing the antitrust laws. So to use John's turn of phrase earlier, maybe I feel like I'm marinating in antitrust, but maybe I'm just alone in that. Maybe I'm just particularly attuned to it, so it feels like there's a lot when it's more modest. So I did just a little bit of digging. I went into Lexis and Westlaw and took a look at, in their news repositories, did searches and this is just in headlines and titles for antitrust and tech or technology. And what I thought was super interesting is up until a couple of years ago, really, you didn't see more than a handful of these each year. There's a little bit of a bump in 2016, starts increasing again in 2018, and then this year has really gone from, hovering around mostly below 100 a year to several hundred. And again, as the previous slide shows, a lot of these are, very critical of tech and antitrust. It's a lot of hostility. And reminiscent.
Sorry, what are the lines? There's a blue and a red. And I don't
The blue is Lexis,
Okay.
and the orange is Westlaw. And it was just their news repositories. There were a couple other things I did to try and limit it to the US, but they each had different characteristics I was able to control for. So there's, and you can see like Lexis this year is showing in blue a lot more cases, but there's a pretty clear spike.
Yeah.
So what is the antitrust and hospitality tradition? So the former Assistant Attorney General for Antitrust, Donald Turner, is largely credited with coining the phrase. He was asked how he would analyze certain restrictions in antitrust, and he quipped, "I approach territorial and customer restrictions not hospitably in the common law tradition, but inhospitably in the tradition of antitrust law." And at this point in time, there's Mark Knifer at DOJ actually has a really good article about how, Don Turner says this, but that's not really what he does. He's actually much less hostile and has a big role in moving the courts away from the inhospitality tradition. But it really does reflect the court's treatment of restrictions at this point in time. And the way Easterbrook described it is, the judges view each business practice with suspicion, always wondering how firms are using it to harm consumers. And if the defendant cannot convince the judge that its practices are an essential feature of competition, the judge prohibits their use. So that's kind of what we were dealing with. There was like a presumption that these different kinds of restrictions were going to be unlawful unless you could affirmatively prove otherwise. And that was very hard to do in practice. So we can see the skepticism of unusual, or sometimes referred to as non-standard terms, like courts to routinely condemn, and often under the per se rule, various contractual restrictions, and they do this in pretty categorical and largely sweeping language. So as early as 1949 in Standard Oil, the court says time arrangements serve hardly any purpose beyond the suppression of competition. There's others, like the Supreme Court held territorial restrictions are so obviously destructive of competition that their mere existence is enough. The courts held minimum and maximum price resale restrictions. So, if a distributor or manufacturer wants to have its retailers sell something not below a certain price or not above a certain price, they can't do that because that is restricting the retailer's ability to set their own price and compete. And it's happening in the courts at this point in time with a lot of skepticism, and it's also, economists are susceptible at this point as well, which is, this Coase quote is one of my favorite antitrust quotes, which is, if an economist finds something that he does not understand, he looks for a monopoly explanation. And as in this field, we are very ignorant. The number of ununderstandable practices tends to be rather large, and the reliance on monopoly explanation frequent. So it's a lot of what you're seeing reflected in the case law. There's an assumption that if these companies are doing something, it must be for a bad reason. So we're going to say they're unlawful. So I thought a case example would be good, and I think Taco is an interesting one for a couple of reasons. So first of all, it comes up to the Supreme Court in 1972. By the time it gets to the Supreme Court, the court has already kind of started showing some early signs that it's going to be moving away from the inhospitality tradition. They're modest and tentative steps, but the early signs are there, and especially in retrospect, we can kind of identify the shift. And on top of which, the district court actually does conduct a much more rigorous analysis of what's going on, and it looks a lot more like what we would expect to see from a court today. But nonetheless, when this actually gets to the Supreme Court gives it the old inhospitality treatment and says per se unlawful. So Topco was a joint venture between some small to medium-sized regional markets, supermarket operators, to create their own private label products. And as part of this, the firms had put some restrictions. They each were allowed to sell the private label Topco products in their own territorial was whether that restriction on not selling or marketing outside of the exclusive areas was unlawful. And so the court really dives in and says, okay, so what is going on here? And he notes that perhaps the most competitively significant innovation of the national mass merchandisers, the big chain stores, was their exploitation of the private label products. And he kind of walks through the different benefits of private label products and notes that they are benefits to both the supermarkets and to consumers. So for the supermarkets, they make higher margins on these products, which allows them in turn to keep higher margins and at the same quality is what the court finds, and that allows them in turn to offer lower prices to consumers. The court finds that on average, the Taco or private label products are about 20% lower than national brands. He also finds that the existence, the fact that they have these products gives them better bargaining leverage against the national brands. And so that kind of lays all the groundwork for why having private labels is important. And then he goes on to say, okay, well, could they have done this themselves? And he finds that, like, the only way that you could size of Taco members could have achieved the volumes they needed was to join this cooperative. He finds specifically that a private label requires at least annual volume sales of $250 million or more, and that to achieve maximum efficiency or optimum efficiency, the volume really would need to be twice that much. The Taco members at the time he was analyzing this range in size from $1.6 million worth of sales a year to about 183. And 18 of the 26 members are well under 100%, so well below even half of what they would need. So the court, eventually decides that, generally the Taco members have been independently unable to develop an efficient or effective private label programs. And on top of this, as the members have grown to a point where they can independently undertake a successful private label program of their own, they have actually left Taco. So he finds that the private labels are super important to competition, that these companies could not offer private labels by their own, and that once they have grown to a size where they could, they've often left Taco. So he goes through all of this, does the rule of reason analysis, finds it's okay. The U.S. appeals, it goes up to the Supreme Court, which ultimately reverses. And what is interesting is that the court acknowledges that the Taco members' market shares were only ranged from 1.5 to 16%, with the average being about 6%, and that only about 10% of the sales of each of the Taco members was on the Taco brand. And I think most strikingly, the court acknowledges that the very existence has improved the competitive potential of Taco members with respect to other large and powerful chains. So they find, like the district court did, that this is really important to competition and the joint venture has helped competition, but they nonetheless say, but this is a horizontal restraint and therefore it's a per se violation of Section 1. And the court actually decides as well, so there's this interesting issue that will come up again later between inter-brand competition and intra-brand competition. And they say, although because the Taco, the restrictions on selling in their exclusive areas restricted intra-brand competition, but you don't get to consider any of the benefits to inter-brand competition. But again, Taco ends up being pretty much the high watermark point of Inhospitality in the courts. There were some early signs, and again, just a few years later, in Continental Television versus GTE Sylvania, the court reconsiders the per se treatment of vertical restraints. And the court here, specifically says the market impact of vertical restraints is complex because they have simultaneously can reduce intra-brand competition and stimulate inter-brand competition. So this is the exact trade-off that the court rejected in Taco a few years earlier. And the courts, are finding that the economists have recently recognized a number of ways in which the manufacturers can use vertical restraints, like the ones that issued in the case, to compete more effectively against other manufacturers. And these include aligning incentives, eliminating free riding, encouraging investments. So one of the things the court says here is, if the television manufacturer wants to, like a retailer, to start selling its product and customers aren't familiar with it in the area, it might be a good idea to give someone exclusive rights to sell it, because that gives the seller the incentive to invest in building out the brand and in educating consumers and educating their employees and things that might not otherwise happen if they had to spend the money to do all of that, and then other retailers could sell it more cheaply. So if you could just get all the information you want at one retailer, go next door and buy it for much cheaper, then the original retailer doesn't really have the incentive to continue investing. And so one good example here, counter example, moving beyond in hospitality in broadcast music, BMI. The court looked at whether blanket licenses to copyrighted music compositions at fees that ASCAP and BMI negotiated should constitute unlawful price fixing. So ASCAP and BMI were the organizations that musicians, composers, authors would join in order to sell their rights to their musical compositions. So if you wanted to use the music in a movie or on a TV show, play it on the radio, play it in your restaurant, you would get a license from ASCAP or BMI. They sell, ASCAP and BMI themselves sold these blanket licenses all at one price, and there was a question of whether that constituted unlawful price fixing, because all of these artists who would otherwise be competing to sell the rights to their songs are no longer competing. And the court really does something that's very similar to what the district court did in Topco here, where they find that this is essentially a different product that is being created by ASCAP and BMI. Like it's something the individual artists could not have offered themselves, that costs were prohibitive for licenses with individual radio stations, nightclubs, restaurants. And so the whole here is like truly greater than the sum of its parts. And again, it's, the courts recognizing that these kinds of restrictions before they have treated as per se unlawful really can offer a lot of benefits. And so today the courts will, they tend to embrace economic learning. There's less per se treatment overall within antitrust because we learned that a lot of things that have been treated as per se lawful offer a lot of consumer benefits, and we've decided that the value of those benefits is worth considering and not categorically writing off. So in some cases, the benefits might not outweigh the harms, but we're going to consider them. We're not going to say as a categorical rule ex ante that there aren't enough that we should consider it. And the Supreme Court has recognized in several contexts that the economics literature is replete with pro-competitive justifications for various restraints. Some more examples here, just kind of highlighting how we moved away from hospitality in antitrust. Microsoft is a particularly interesting example here. So the court found Microsoft liable for several different monopoly maintenance counts, but when it turned to the tying counts, which from a few slides earlier, you might remember the court said, tying has basically no justifications other than to suppress competition. Here, the court says, is going to hold that we look at these under the rule of reason rather than per se, and specifically, the court knows that they don't have enough experience with these kinds of arrangements to say that their pernicious effect on competition is so great and so constant that they lack any redeeming virtue. And so it says it is going to look at a software firm's decision to sell multiple functions as a package under the rule of reason and not per se. So that is what we've got so far. So the courts, really reject the in-hospitality tradition. They move on to a more enlightened approach that kind of tries to consider all of the factors that are going on, try and get to an outcome that is overall better for consumers. But a lot of what we're seeing today in the popular debate is a lot more critical, a lot more reminiscent of what courts were saying back in the day, back when in-hospitality ruled. So Senator Warren, for example, has made this a big part of her campaign. She put up these billboards out, I think in Silicon Valley in San Francisco, like went right after big tech on their home turf. And she has this quote that's been used several different places that's saying you can be the umpire, that is you can run the platform or the marketplace, or you can have a team in the game, that is you can be one of the competing businesses, but you don't get to do both. And so, along with that, there's a lot of other calls to kind of go back and ban these kinds of things, ban vertical integration. Lena Khan, in one of her papers, argues that restoring traditional antitrust principles, and by this she's referring to the inhospitality tradition, that like banning vertical integration by dominant firms can help maintain competition in these marketplaces. There's some other folks, Matt Stoller makes a similar argument as Elizabeth Warren about not being fair in demand. And then there are some other arguments that have been put forth as well in a similar vein. So, limiting vertical integration in firm size, breaking up firms, not allowing discrimination or self-preferencing. So if you're Google, you can't show, and someone searches for email, you can't put Gmail at the top, or any of your own things. And others, which, so Chris talked about earlier today, Salop has been arguing for increasing vertical and merger enforcement. Some others have just been arguing a bit more for more vertical enforcement, not as much of a regime change, but there's a lot of calls overall kind of looking to be more aggressive and a little more hostile. And so, since Roger was the earlier speaker on this panel, I thought I'd talk a little bit about some of the international foreign reports that have been issued or commissioned by some foreign governments. And some of these as well are arguing for quite a more hostile approach to big tech in particular. So the EC has a report that says one may want to err on the side of disallowing potentially anti-competitive conducts and imposing on the incumbent the burden of proof for showing the pro-competitiveness of its conduct. So, from a few slides earlier, you remember Easterbrook, when he was explaining what the courts are doing under the inhospitality tradition. It is essentially this, right? It's putting the burden to prove definitively that your conduct is not harmful rather than allowing firms to act and forcing the government to prove that what they're doing is affirmatively harmful. The Australian Competition and Consumer Commission similarly argues there's a risk competition might be hindered due to vertically integrated nature of firms like Google and Facebook. And the German Federal Ministry for Economic Affairs and Energy recommended a ban on giving preferential treatment to a platform's own services over those of third parties. Not all of them are quite so prescriptive and aggressive, though. The UK recently issued a report. Ofcom is their communications regulator. It's called Online Market Failures and Harms, and this tries to systematically go through what the potential harms are. And since it's a communications regulator, the report's a little bit broader than some of the other ones, but it's also a little bit more reasoned and cautious in its approach. It doesn't offer yet any specific prescriptions as to how antitrust law should change. And they note it in some instances self-preferencing by a large platform might enable it to enter into the provision of a new service in competition with other platforms. And in such a scenario, a blanket ban on self-preferencing for large platforms might actually reduce rather than enhance competition. So this looks more like the current approach the U.S. courts taking antitrust that's more hospitable, less inhospitable, but it's a little bit of an outlier right now, it seems. And so I wanted to point out as well that in addition to being reminiscent of a past era in antitrust enforcement, this is not the first time in the modern era either that we've heard calls to break up big firms. So we've heard about earlier in the decades, AOL's incident at messaging monopoly, potentially MySpace's monopoly, and whether that would ever end. And another recent one is Walmart. And so Walmart, and I don't know how to get rid of that guy. Anyway. So for Walmart, a lot of the calls are very similar to what's happening with Amazon. It's too big, they're doing too much. And one of the things that's interesting is there have been studies that have tried to estimate the benefits of having someone like Walmart in the marketplace. And if you think about kind of what you spend your money on when you go to Walmart, it's a lot of staples, it's a lot of things that you need to buy, like food and these kinds of things. So in this report, Jason Furman notes that, first of all, the value of Walmart is enormous, estimating $263 billion in 2004, or over $2,000 per household. And he also, the point that I think is very interesting, notes that ends up being a very progressive benefit in that if you're a lower income, you just have to spend more of a larger percentage of your income on things like food. So that ends up, the savings from Walmart end up being disproportionately beneficial for people in lower incomes. And so calls to break up Walmart, especially calls to break up Walmart on the grounds that it is harming poor people, might be a little misplaced. On top of which, self-referencing is not in fact new. I took a screenshot because I didn't actually want to go to the store. But you see this in brick and mortar stores. It's been around for a long time. If you go into CVS, and I think the over-the-counter painkillers are a really good example because they are identical to the name brand painkillers. They just have, like in Topco, they have a private label brand, the store brand, and so they're able to sell them more cheaply. So online, if you search CVS's website for just ibuprofen, which is the name of the active ingredient, it will give you all of its CVS brand first. And if you walk into a store like CVS, a lot of times they'll put the CVS brand right next to or right on top of Motrin and Advil, and they'll have their big yellow signs and say like, oh hey, check out our CVS brand, it's the exact same thing, only costs less. So this is something that's been around for a while. It's not new or unique to the tech space. All right, I have way too many slides. So turning now, I wanted to talk about, there's been this kind of resurgence of popular interest in a more inhospitable approach to technology and antitrust. But is that really something that would be good for consumers and good for the world? So the first question you want to ask is whether there's a market failure in big tech. This is kind of the basic principle is you want to identify a market failure before you consider regulatory solutions, because we have generally a free market system. We think that's the best way to get goods to their most highly valued use. And so if we're going to intervene and try and disrupt the free market, we want to be doing that because we think there's a problem and not just because we think there might be a problem, but we haven't identified it yet because we might do more harm than good. And as a sub-point, then I'm just going to bracket for now because we're not going to get past this first point. Even if you do identify a market failure, the next question then is whether government intervention can enhance outcomes. Like, what's the best next step? It's not necessarily obvious that the next right step is for government intervention. So, do we have empirical evidence of a market failure? So, there are a lot of reports that I mentioned before. The EU, the UK, the ACCC have put out reports, but so far these are really outlining theories of harm that they think might be happening, ways in which big tech companies might be foreclosing rivals or otherwise harming competition, but there's really not in these reports any empirical efforts to demonstrate any harms to consumers. So we have mostly theories of customer or input foreclosure, but no real evidence. And again, theory alone is not enough for a good policy. There's a very small chance that I might have a long-lost relative who will die in the next few years and I'll receive their immense inheritance. Probably not a good theory though, so I should probably not quit my day job. And on top of this, there's very strong evidence of really enormous consumer surplus in various tech areas. So as a precursor, I'm going to talk for a couple of minutes about some of the benefits that have been identified in tech, and specifically these will focus on trying to identify consumer surplus. So Brynjolfsson, whose name I'm sure I'm butchering, argues that while GDP measures production, it's not meant to measure well-being. And so consumer surplus is kind of a better way to get at how much consumers actually benefit things. And one of the examples he gives is that so for music in particular, people, you used to have to go out and buy albums. If you wanted to listen to someone's music today, you can go on YouTube or Spotify, so there's no longer revenue that's being contributed to the economy in that case. Instead, you're listening to it for free online somewhere. So the actual GDP measures for music, the music industry might have gone down, but consumer value, consumer surplus actually goes up. So Brynjolfsson et al. Have a paper from this year in which they kind of look at the willingness to accept. So how much would you have to pay someone to not use search engines, email, online maps, videos, all these different columns for a year? What is particularly striking is that you'd have to pay, the study found, nearly $18,000 someone not to use search engines for a year, which is a really tremendous amount of consumer value that's created for a free product. You go online, I was thinking about this and whether that seemed high or low to me and whether I would pay more or less. I think you'd have to pay me more to stay off search because I'm so reliant on it at this point. And one of the things they note, and I'm just going to point out because hopefully I'll get back to in a minute, the video streaming services like YouTube and Netflix aren't necessarily free, but you might pay like $10 to $20 a month. And their findings suggest that even with these kinds of things, right now, consumers are getting like a 5 to 10 multiple of what they actually pay in terms of value. So a couple more examples.
It's willingness to what?
Willingness to accept.
Okay.
So, so a couple more. There's a couple of studies that are also specifically looked at Facebook and Uber. The Uber study in particular speaks to me. I used Uber a lot, and I mentioned earlier I spent a year living in Jackson, Mississippi before Uber arrived. They don't have a great public transportation system. I think there were like 2 taxis, so that really wasn't an option. I had gone there for an interview. When the person I interviewed with found out that I had taken a taxi from the airport, they were horrified and insisted on finding me a ride back. So Uber came, and I've been to Jackson since, and it really has made a big difference. And part of the downtown of Jackson has been revitalized in a lot of ways, and not that that is all attributable to Uber, but Uber definitely helps because a lot of it is bars and restaurants where people can now get to where it was much more difficult to get to before. So this study found that in 2015 alone, kind of using back of the envelope calculations, they found the consumer surplus generated by UberX in the United States just in 2015 again was nearly $7 billion. And a similar study looked at kind of the willingness to accept to deactivate Facebook for 4 weeks, and found that 4 weeks of Facebook generates about $31 billion of consumer surplus in the US alone, which is pretty wild. So we'll go through this pretty quickly because I've been talking for a while now. But on the other hand, so we have all this evidence of a lot of consumer surplus coming from big tech, and the empirical evidence on the effects of vertical restraints have shown pretty consistently and repeatedly for the last few decades that these tend to be good, they tend to be pro-competitive or competitively neutral, and rarely end up harming consumers. So these studies will, kind of look at the effects of vertical integration and vertical restraints and try and, figure out what happens to prices and different measures of consumer welfare afterwards. So here are some more. Cooper in 2005 finds there's a paucity of support for the proposition that vertical restraints and vertical integration are likely to harm consumers, and that a far greater number of studies found the use of vertical restraints in particular context studied improved welfare unambiguously. O'Brien finds similar things, and the Global Antitrust Institute, which John is a part of last year, submitted a paper to the FTC during its Competition and Consumer Welfare in the 21st Century hearings that updated this literature to include the papers from 2009 to 2018, and similarly found that consumers mostly benefited from vertical integration. So we have a lot of benefits, little empirical evidence that vertical restraints are actually harmful. There's a few exceptions. I think when you're considering policy in this area, your question is, the key question is, what are the exceptions? And right now, we don't have a robust methodology for distinguishing ex ante which restraints are going to be good and which are going to be harmful. So unlike with the horizontal mergers, say, where we have a lot more methodology, we're more confident in our predictions as to what's going to happen post-merger. With vertical integration, because there are these competing effects, it's harder to say ex ante when we haven't identified characteristics that can help us decide until we see what actually happens, which is more likely. We understand from the empirics that In fact, the benefits are more likely to be what we observe in the real world, but that doesn't exclude the possibility of harm. And unfortunately, also some of the characteristics that make foreclosure and harmful outcomes more likely also make efficiency gains more likely. So we talked earlier today about elimination of double marginalization, and you might expect there to be more of that if there's more market power, but you also might expect that it would be easier to foreclose competitors if you have more market power. And there are also so far hasn't been any evidence that the effects of vertical restriction and integration in the technology space is empirically different or likely to be more harmful than vertical restraints and integration in other industries. So, kind of getting towards the end now, I thought it might be interesting to think about what would the streaming wars look like under an in-hospitality system. So Netflix has been around for a while at this point. You know, they basically pioneered this whole online video streaming idea. Hulu's been around for a while, but recently, in the last couple months, this is really, the competition for online streaming services has really started to heat up, and as The Verge and others have acknowledged, like, it seems to be that Disney Plus in particular, their announced entry to the market, has really like catalyzed a new level of competition in this market. And I have on the screen several of the players in the space, and as you can see, if we're taking an approach that disallows vertical integration and vertical expansion, you know, more categorically, let's say we're prohibiting other big companies from entering, so you wouldn't have YouTube, you wouldn't have Amazon Prime Video or Free Dive. It's unclear whether you could get Disney Plus. They're kind of in an adjacent market. It's, I guess, depending how you define the market, it would still be, Disney is already a very large company, so some of the proposals would almost certainly prevent Disney from expanding further. Apple certainly wouldn't be allowed. HBO is already there, but also companies like NBC, CBS are trying to expand into this space, and it's unclear, depending on how aggressive we would be, if it was a total ban on vertical integration. Some of the arguments have been that we should, you know, have someone in charge who's deciding, a regulator deciding who is allowed to expand and how far. Which, working at a law enforcement agency, I can tell you, I don't know how you make that decision. I think that'd be really challenging to try and figure out a principled way to manage the market in that kind of way. So at the end of the day, there's a question really, I think, of whether a return to in-hospitality would make consumers better off. And one of the key questions is whether it would enhance innovation. You know, we talked about a lot of the consumer surplus that's in tech today, and I think that's not to say that the tech companies aren't doing anything wrong or that there aren't ways in which competition is being harmed, but I think as a whole, what we're seeing is there's a lot of consumer surplus, so it's hard to justify categorical bans when you're seeing surplus, because it's not that we're going from negative welfare effects to positive welfare effects. It would be, you know, you're going from very positive welfare effects to even more positive welfare effects. I think that's just a harder argument to make. Again, it's hard to argue, I think, that there's a systematic market failure as opposed to maybe specific instances where things have gone off the rails a little bit. We talked about it a little bit earlier today also as well. There's not really a robust theory that we have that links innovation to market structure. So different markets, there's a lot of theories around this as well, but what we seem to find in practice is that different markets can be competitive under different conditions. So counting the number of firms in the market isn't necessarily a good way to determine what innovation is likely to look like. And we also want to be careful. Some of the prescriptions that are being made seem to assume that new entrants are inherently more innovative than incumbents, and it's not always clear that's the case either. Some other considerations: what happens to firm growth and expansion? Again, earlier today we touched on the point that a lot of startups, they started with a specific market exit strategy of being bought by another company. And again, as the previous slide suggested, you know, we're limiting vertical expansion or a certain amount of growth. That might be limiting the number of options for consumers as well. And as the final point, just wanted to note LaFontaine and Slade as well, who, you know, we had studied vertical integrations quite a bit. Some of what they did also looked at when government enforcers had actually intervened, and they found that consumers were generally worse off when the government's required vertical separation. And they recommended that given the weight of the evidence, it behooves government agencies to reconsider the validity of such restrictions. So that is all that I have.
So questions, comments for Elyse? So I will start with one then, and then Tom, you go first. Was that?
You let me go first?
Yeah.
So, I mean, I think you're undoubtedly right about this inhospitality, new inhospitality toward tech. And I think you make a really persuasive case that it's unjustified and that it's likely to reduce social welfare in the long run. And I'm super sympathetic. It's the same argument that I make. And I think it just falls on deaf ears because there's this really weird moment, it seems to me, with tech, where you've got a sort of perfect storm of, for lack of a better word, progressives that are just sort of reflexively suspicious of sort of big business, and so don't like these powerful tech companies. And then you have a lot of conservatives, including my most notably, perhaps, my former colleague and friend, Senator Josh Hawley, who I've gone round and round with on this stuff, who say, well, look, I agree with Elizabeth Warren. We got to break these guys up because they're biased against us, and they're not us. I mean, we're a disproportionate share of the benefits of these big businesses go to the elites on the coast, and we're the red folks in the middle, and and I guess that must play well. I mean, it doesn't play well with me, but it must play well with other folks in Missouri, where I live. So I'm just sort of wondering how if this is an argument that is actually going to have an effect on the policy front, given that you've got this perfect storm between sort of populist conservatives and reflexively, anti-bigness progressives. What's a technocrat to do, Elyse? That's my question.
Yeah, no, it's a really good question. I have the same fear as well, that there's a lot of pressure coming from a lot of different ways, and it all has weirdly come down. It's coming down from different places, and it's sometimes in very different respects. Like, some of it is about democracy, some of it's about bias, some of it's actually about antitrust, but all of it ends up being we should break up the tech companies. So yeah, I think that's really tough. It's one of those things with the FTC we have been trying to, we keep doing what we're doing, right? We enforce the law the way it is now, and we kind of Christian talked about this earlier today. There's, we don't want to throw everything into the antitrust bucket, which again seems to be a little bit of what's happening. So we're hoping that the agencies, to the extent they do decide they want to break up tech for whatever reason it is, that that's a decision the legislature makes. Because again, I think it's trading off on a lot of different values that antitrust regulators, especially at the FTC, is an independent agency. The commissioners are not removable by the president. They shouldn't be the ones deciding these kinds of big picture policy ideas for the country.
Yes.
Yeah, so I just had a question about your consumer surplus stuff. So I read an argument about, so basically like Uber, for example, because it operates at such a huge loss, eventually consumers are benefiting from like a subsidy from venture capitalist investors in Uber, and inevitably when these venture capitalists demand a return on their investment and they want Uber to be profitable, and they eventually raise prices. So over time, some of these tech companies, their services do get more expensive. Does that reduce the consumer surplus that we see from these tech companies and maybe change the argument in any way?
Yeah, I think that's a good question. It's hard to see over time, so that's an argument that's also been made about Amazon in certain ways, right? Like, it doesn't make a lot of money on its retail, it never really has. So long or if like Amazon, Uber is going to have to try and find another way to monetize that is different. But I don't think that means, and I mean, it just kind of depends, I guess, also on how much Uber is expanding over that time. Because if they continue expanding and some of the value, they have to raise prices somewhat. That doesn't mean that consumer surplus necessarily goes down at all. And in antitrust, there's also, if you're a monopolist, you can charge the monopoly price, right? Like we generally allow firms to set their own prices subject to very limited constraints. If we think they've engaged in some sort of anti-competitive conduct that has allowed them to raise their prices, that might be something different. But to the extent it's not, to the extent that Uber hasn't done anything anti-competitive, they just are losing money and need to raise the price, that probably is less likely to be a problem that antitrust law covers.
I mean, I think it's really important not to paint with a broad brush. The Inhospitality is not about technology companies generally. It's not even about big technology companies. It's really only about Facebook and Google. I mean, if you look at the largest tech companies in the country, Apple, Amazon, Alphabet, Microsoft, IBM, Dell, Intel, HP, do you hear people say we should be breaking up Intel?
So that's
Dell, or I mean, no one's talking about, the vast majority of the companies we're talking about, no one's saying break those companies up. It's all about the monopoly power of Facebook and Google.
Yeah, I think it is right now. My fear,
Maybe Amazon, but very little of that.
yeah, I think my fear is that a lot of the same arguments that apply to Facebook and Google, it's a slippery slope once you start saying, okay, well, we need to break these companies up for these reasons. Because, you're right, Microsoft, again, Disney, a lot of these companies, you can say they fit into a very similar mold. And I think it's hard once you get started, like down the road of saying, like, we can break these companies up for these reasons. There's not a ton that distinguishes necessarily the other companies, especially if we successfully break Facebook up and it's a lot smaller, then Microsoft looks a lot bigger than it did yesterday.
Comment based on the conversation here. One, in a kind of silly way, when I think about the idea of Uber losing money for consumers or Amazon, it's like they're giving consumers a loan in the present that they so they're lending the money for a while, and if later they go out of business, that's good for consumers. Kind of a silly way to put it, but I think it's true. On the we're only talking about these other ones, and Blake, your thoughts on this? I feel like it's a tip of the spear kind of approach, right? So if you actually read a lot of the advocates who are going after the big tech companies, they'll focus on Facebook and Google, but then if you read their newsletters and like their smaller writings, they're like, well, you got to look at this industry and this industry and this industry, and they keep repeating the same claims on there. So what they're trying to do is I think what they're trying to do is get into the popular imagination, this concept that a certain type of firm deserves it. And by the way, these other ones, we're getting to them next. I think that is a long-term strategy. I don't know if you agree with that.
Yeah, I think, that's my impression is they're trying, a little bit of it is to normalize
They're beta
more
testing
regulation
their approach.
and, breaking companies
Can I
up.
respond to that? So that may be true for the think tanks and the sort of new Brandeis folks, but our enforcement agencies saying, oh, Google now and Intel you're next, and then Dell after that.
Well, they went after Qualcomm.
They went to Qualcomm, but I don't think it's accurate to say that there's an overall appetite to go after big tech companies among enforcement agencies. I think that there's specific companies that have specific problems for the enforcement agencies, not for the think tanks.
Yeah, no, I think that's a very fair criticism.
Although that may depend on the next election results too, right?
Yes,
I mean,
absolutely.
that's
And if you lay that ground for now.
Yeah, so I think right now there is the popular debate outside of the enforcement agencies, the think tanks, some of the politicians, it's much more aggressive than it is, certainly at the agencies, or in the courts yet as well. Like, I don't think any of...
So I have coffee with these people and I say, this is great as an academic argument. What does your litigation shop within your think tank argue? What are you going to argue among your litigators? And they said, well, we don't have a litigation arm of our think tank. I said, well, what would your litigators say if you're going to try to win this case before a traditional judge using traditional jurisprudence? And they don't really have an answer.
Yeah, I think that's what's tough. I do think we've, in the courts definitely, and in the agencies, moved past the hospitality tradition, so it would, I think, require some kind of backtracking somehow, and I don't know if you can get the courts or the agencies that is my fear, that the more normal we make it, the easier it is.
Other questions? Otherwise, that seems like a good place to stop. So, thank you, Elyse.